We are live. Hi, Seth.
Hi, we're 2 minutes late. Wasn't my fault this time.
But are you insinuating it was my fault?
No,
I'm
there's
not
only
sure
two
I
of us
like
here.
I'm not sure how I like how this is
We
how
can
this is
blame it on
starting.
Andy.
Oh, he's not here. Right. We
He-
are starting. Welcome to the live stream. We're glad you are here. If you are watching us live, please make sure to send us some questions. You can post anywhere you are watching, and those comments should be fueled right back to us. And we would love to hear what you are thinking about today's subject. Here we go. Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, toaster, you're off the hook, but don't get used to it.
Welcome to the show, everybody. I'm Seth Nelson. As always, I'm here with my good friend Pete Wright. Today, we're diving into the murky waters of temporary relief. I'm doing that in quotes, Pete, in Florida divorces. Imagine a couple, let's call them Alex and Sam, locked in a bitter separation, once again in quotes, as their assets freeze and the tensions rise. Who pays the mortgage? Who gets to stay in the family home? And what about the children caught in the crossfire? Enter the concept of temporary relief, a legal lifeline designed to keep families afloat in the choppy seas of divorce. Sounds
Now,
like the opening of a book.
one, I want you to know just how much I wanted to make it Florida ocean kind of. I wanted to give you a theme when
Yeah,
we looked at that introduction. Choppy waters, nothing smooth there right now. Nothing.
I heard that. It's a
Good.
little
All right.
too
Too
soon.
much?
When you tell a joke too soon to the hurricane coming through, Pete,
Yeah.
a little too soon.
I'm so
Okay.
sorry. I'm so sorry. Too soon. We are talking about temporary relief, and I feel like this is a concept we've danced around and probably did just a dash of mind blowing the last time we talked about it. Today, you're going to answer the big question: What is it? Who does it help? Who does it hurt? Why do we care?
Yeah, there's a lot all bundled in there in pros and
Yeah.
cons. So let's just talk about conceptually what it's supposed to do and what do the words temporary relief mean.
Hmm.
We all know temporary, that's just not permanent for a short period of time. Then relief, what is relief? Well, in the law, we like to use terms to confuse people, and relief is one of them. What are you asking the judge to do? That's the relief you're seeking.
What I hear is I'm getting a break. There's something that hurts me, and I'm getting a break from feeling that pain.
If things go well.
Okay.
So, what happens a lot, and this is not going to be a surprise to any of our listeners, it won't be a surprise to you, Pete. People don't always play nice when they get divorced, and one parent might or one party might withhold the money and stop paying the bills. Another one might run up credit card debt. Another one might withhold the children. Another one might um, start cashing out stocks and bonds, um, canceling people's car insurance or health insurance, and all these really, really bad things that lawyers advise their clients not to do. But people do it anyway. So when that happens, or let's just say someone's paying all the bills, they're doing everything they're supposed to do, but you don't have money for an attorney and you need
Hmm.
attorney's fees, but you don't have access to any capital, any cash, any credit cards. You just don't have it. What can you do?
Hmm.
In Florida family law, you can file a motion, which we've covered what a motion is,
Hmm.
a motion for temporary relief. That's the title.
And
And
that just says we want the judge to move his hand or her hand to sign on the line which is dotted that
that's right.
says this is in my favor. Okay.
This is the order. I'm
Hmm.
signing an order. Perfect. And what you're going to do in this motion is ask for potentially the following things. I want a temporary parenting plan. Judge, the kids have a right to know what night they're going to spend with each parent.
Hmm.
They have a right to know what parent's going to be in the house. They have a right to know um, who's going to take them on what weekends and what a temporary holiday schedule might look like. And I want you to order that from the date of your order till the final judgment, which either will come if people agree and they enter into a parenting plan, Or at the end of the trial, this is the rules that I want to have in place. This will be the temporary parenting plan. So that's one thing you might ask for.
Okay.
Seems
That sounds completely reasonable right now.
it does. It's just hard to get there. We're going to talk about it.
Okay.
Okay. So then if you're there, you might as well talk about other things. The next one in our piece, parenting plan, equitable distribution, alimony, child support, everything else. You might want to ask for a partial or an interim distribution of marital assets. There's $200,000 in the bank and Alex has control of it. It's only in Alex's name. And then Sam says, I want 100 grand of it, Judge. We can argue later on whether or not it is going to be the division of assets under equitable distribution. We can argue later whether it's going to be temporary alimony that got paid. We can argue later whether it was child support, but I want 100 grand that I have control over. Okay.
That just
I'm willing.
says we'll figure out the who owes who later, but right now I have pain, and that 100 grand is going to help me not feel so much pain.
You got it. Okay. Then you go to temporary alimony.
Mm-hmm.
Say, Judge, if you don't give me the 100 grand, or maybe you ask for them both, I need, and this is Sam talking, I need Alex to pay me $6,000 a month in temporary alimony. Okay.
Mm-hmm.
And when you do that, and I do the math, if we go to child support, here's what Alex should pay me in child support based upon the parenting plan that I think should be temporary as well.
Right.
Okay.
Mm-hmm.
And then based upon that, here's what I need for my attorney's fees and costs. And there's certain rules in different jurisdictions within Florida because Florida, any Florida judge that's a circuit court judge can hear any divorce anywhere in Florida. But venue, where the case is actually heard, is another concept. So if you're in Hillsborough County, be careful everywhere. Check your local rules. Check any administrative orders, because depending on how much you ask for, your lawyer has to do certain things. If you're asking for 10 grand, just go in and ask for the 10 grand. Let them know how many hours you'll take, what your hourly rate is.
Yeah.
But if you're asking for like 50 grand or more, you might have to have more detailed understanding of why do you need 50 grand as opposed to 10.
Can you give me an example of what that might look like? If I
Yeah.
let's just say I'm asking you, it's going to
Yeah.
be 50 grand. Tell me what you're going to write in that report.
If it's you, Pete, we're going to make it 150. So here's what we're going to do.
Okay. All right.
We're going to say, Judge, unfortunately, in this case, I represent Sam. Alex suffers from alcoholism. We're going to need a social investigation and an alcohol assessment. We might need SoberLink. Before you even do a temporary plan, I want him to be on SoberLink, and I need to prove that to you. So I'm going to need money for that. I'm going to need a social investigation to do psychological evaluation because Alex was Baker acted 3 years ago. They're like, oh, Judge, 3 years, not since then. You don't need that, right? Back and forth.
Yeah.
That's going to cost 20 grand. We have Alex runs a closely held business. I'm going to need a forensic accountant, and that forensic accountant's going to cost me 30 grand. Right.
Okay.
So it's all these temporary fees.
Adds up.
Right. Right. Not
so far, though, so far, all those fees are like directly in service of the case, right? I mean, the specific investigation that you're doing for the case.
Then Mr. Nelson's representing me.
Uh-huh.
And he is going to have to do, and this is what I would do as the lawyer, Judge, I'm going to have to do depositions. I'm going to have to do discovery. I think the deposition of these witnesses is going to take 4 hours. The transcript of a 4-hour deposition is going to be $2,300. So that's my estimated cost. So you go through everything you think you need to do.
Yeah, got it.
And then you file it. And the judge looks at it and says, Mr. Nelson, you're worth every penny, but I don't think you need an 8-hour deposition for that witness. You can get that done in 3. So
Okay.
I'm only giving you temporary fees for now for 3, not for 8. They're going to cut that temporary fee award. Okay.
Yeah.
So you have to justify it.
Okay. And the judge has say
Judge has
in the line.
Unbelievable amount of discretion.
Okay.
And the reason the judge has so much discretion is this is a non-final order. By its definition, it's temporary. And on all these orders, the judge will write without prejudice, which means you can work it all out at the final hearing, at the trial.
Okay.
If the judge
That's what
awarded,
defined. I don't get so prejudice in legal term.
yeah. So if it's with prejudice, the judge says in this temporary relief, and this would be a mistake for the judge to do, but I'm just giving you an example.
Okay.
The judge goes, I am giving the wife $7,000 a month in alimony during the pendency of this case with prejudice, which means when you get to trial, you're no longer allowed to argue that it shouldn't have been $7,000. Alex is stuck with that number. Okay.
Oh, okay.
It really should have only
That
been
doesn't
30.
sound temporary at all.
Right. It really should have only been $4,000. So Alex is paying an extra $3,000,
Mhm.
and Sam knows it. Sam's lawyer knows it. And
Okay.
Alex has to pay that $7,000 until the end of the case. What does that incentivize Sam to do? Delay the end of the case.
Delay the end of the case. While
'Cause you're getting an
Alex is incented to end the case.
as soon as possible.
Okay.
But so that would be with prejudice. You're stuck with it.
Okay.
Okay. Without prejudice means, Sam, I'm making Alex pay you 7. I know you think that you needed 9. Sam thinks you only needed 3. I'm giving you 7 now, but at the end of the case, I might give you 9. I might give you 7. I might give you 0. I might give you 3. But if I give you 3, Sam has already overpaid $4,000 a month.
Yeah.
For how long? And that's coming from somewhere.
Right.
Okay.
Coming from future payments.
Maybe future
imagine,
payments.
right?
Maybe when you divide up that $100,000 or $200,000 and he's already overpaid
take
$3,000 or $4, you
12,000 off the top of
whatever
that.
the case is.
Okay. All right.
Okay.
All right. I get it.
So then it's without prejudice means you can argue about it later.
Yeah. All right.
And the reason why these are so important is, let's say the judge gets it wrong. You're going to say, that's okay, Seth. I've learned some stuff on this podcast. The toaster's teaching me stuff.
Mhm.
We can go to an appeals court.
Okay.
We can appeal it.
Of course,
right?
we can always
That's
do
what
that.
you're going to say.
But does
You're
this
gonna say,
temporary relief last until the appeal is done, or just until the initial decision?
You're going to say, let's go talk to Judge Lucas on the appellate court. You're going to go to Judge Lucas, and Judge Lucas is going to say, Pete, good to hear from you again, but this is a non-final order. It's without prejudice. The appellate court is only going to review this if it's a final order, and it's not. On the face of the order, it says temporary. It says in the body of the order, without prejudice. Go back and talk to the trial judge.
Okay. All right.
Now,
so we're waiting. So we're waiting for a final order. Okay, go ahead.
The other thing about temporary orders, they're temporary. You can file a motion to amend the temporary order during the pendency of the case. So you can have more than one motion for temporary relief. You're not one and done.
So I need clarification on that. May it please the court.
Yes.
Are we talking about a temporary order on top of a temporary order on the same topic? Like, for example, alimony.
Yes.
So you could get your 7 and then come back and say, I need another 2?
Yes. Or the other one can say, Judge, we have more information. I'm filing a new motion for temporary relief. We had a forensic accountant. The forensic accountant did an analysis, and this rental property we have is doing a lot of cash, and it's her non-marital rental property. So it's not marital money, and she's getting income for that. That income was not considered when you did the original temporary relief. When you gave her the 7, she's getting an additional $4,000. She only needs 3.
Okay.
Moving sands, shifting sands.
Okay. So what
I
happens?
kept up with the theme
that?
of the hurricane on that.
It was really good. I like that. No, I appreciate your consistency. What happens to the initial 7? Is it just, are we looking
at changed.
Net? Okay. So the 7 is still in place, but it gets changed to 3, or?
Yep. You got it. He's been paying 7 for 6 months. Now he's going to pay 3 till the end of the case.
All right. And because it was without prejudice, once we reach a final judgment, then we're going to hash out the differences.
You got
on the back of a napkin.
Or in court through objection-related testimony.
Outstanding. Okay.
Okay.
So far we've talked about all kinds of money-related things and some child support-related relief. What else is there that we need to consider?
Just the parenting plan. Where the kid's going to stay? What's that going to be on a temporary basis?
Okay, can I got to ask a question about that. So, what about assets? Is there any temporary relief related to because we've talked about like exclusive use of the home, right? Of the
Hmm.
marital home. Is that something you could file a motion for temporary relief that says, "Hey,
Yes,
okay, so this is going to be my house until the end of the case and you can't come in for
that's
one reason
correct.
or another." And that's where the kids are going to live and that's where, everything's going to be fine, but only until the end of the case we'll figure it out.
That's right.
Oh, well
You
that was
can go
easy.
ask for temporary relief for anything. Doesn't mean it's going to get granted,
Okay.
but you can ask. Okay.
Freezing assets? Can I go in and say, "Hey, I want my wife not to be able to use the boat"?
You can. You can.
Oh,
Yeah.
I
And
mean, I
I've had,
looked really greedy about that. There's nothing exciting about that for me. I
well,
don't even have a boat.
right. But here's, if that's what they say, my response is, Judge, no one should use the boat.
Playground rules.
It's a depleting asset. You're putting more miles or more
Wear
hours on
and
the engine,
tear on the engine, yeah.
right? So there's a lot of arguments to be made.
Okay.
Okay. So arguing over toys is always difficult.
Yeah. All right.
So this all sounds good. And the reason why temporary relief is so important and a really good thing to consider, I'm using that very clearly, to consider. I'm not saying you do it in every case, is because if someone's controlling stuff and you can't work it out and you try to work it out, if you go to court on temporary relief, it can even the playing field.
Okay.
Someone's withholding the kids, you get an order 50-50. Now it's even the playing field on the kids.
Okay.
Someone's withholding money, they're trying to like drown you out there. You get a temporary alimony award, you get temporary child support, maybe you get a sale of a asset or a division of an asset, maybe you get some attorney's fees. Like it starts evening the playing field a bit on all these issues. Okay.
Yeah.
So doesn't it just make sense, Pete, if that's what we should do? After you file for divorce, the court should just set a temporary relief hearing to deal with these issues, to get people in there and figure out this stuff so they don't fight about it.
I'm so glad you brought that up because that was going to be my next question is talk about process. How does one do this? And are you just buried as a divorce attorney in constant like requests for temporary relief from your clients?
No, you're not. And here's why. One, they don't necessarily know about it. But if they say, like, he's choking me out, I can't do this, or I'm drowning
Uh-huh.
in this, right, okay, we can do a motion for temporary relief. And we file our motion. The court will require us to go to mediation first. So
Okay.
now we have to go mediate it. What are the chances that someone that's purposely not giving kids or purposely not giving money gonna settle on time? Like they'll go to court.
Yeah, right.
Okay.
So
Now,
they're not going to go to
maybe
mediation, but we already know even trying to schedule mediation is challenging.
there you go.
And if I know anything, it's that every motion is going to require a hearing.
Yeah. So first we go to a motion for temporary relief. The judge orders us to mediation. So sometimes immediately I just do a motion to set mediation because I don't want to sit there and get jerked around about not going to mediation.
Right.
So they're going to say, I'm not ready to go to mediation. I don't have the financial. I set a motion. And my motion, I also will ask for discovery deadlines. Like, Judge, we're getting no money. Here's the
Mhm.
problem. Here's when I want the discovery done. I have a motion for temporary relief. I want to set up for mediation. Like, push it, push it, push it. Right. Of course, sounds good, but you still got to get in court to get that all heard. That could be
Yeah.
months.
Well, and that's what I was saying. Like when you say I'm going to push it, push it, push it, what is your internal time clock? Are you saying I'm going to push it and that's
6
going to be for
months.
next Tuesday? Oh,
6 months.
okay.
I'm
6 months
telling
is
you.
you hustling.
I'm telling you, usually 4 to 6 months if I file right away on temporary relief.
So temporary, when we open this conversation, temporary relief, there's some pain. If it goes your way, you're going to be feeling less of that pain for the duration of the
Yep,
case. But that implies a sense of immediacy. Temporary relief says, I feel pain now, and I hope you can make me feel no pain now. And what you just said to me is don't get your hopes up.
that's right.
You're going to be feeling pain for at least 4 to 6 months if things go your way.
That's right.
Awful. Okay.
Terrible.
'Tis the system.
which leads me to the pros and the cons. And you
Okay.
asked a very good question. Man, are you just dealing with temporary relief all the time? No. And the reason for that is because if I'm fortunate and I can get your case done in a year, 9, 10, 12 months, right? If I can, do you want to spend the money for me to prepare for a motion for temporary relief and do all of this just to um, then try your case 6 months later or 3 months later?
Hmm.
Because there's a lot of fees that go involved with all of that. Okay. So that's the question.
Yeah.
And one of the pros is you go through it, you even the playing field. The negative is it costs money.
Yeah.
Where I'm like, just hold on, let's get it.
So implies an interesting angle. If you file a motion for temporary relief, schedule another hearing, do motions for temporary relief implicitly delay the final judgment of a particular case?
Not necessarily,
But
because
they can.
you can also set it for trial.
Hmm.
And literally, I've had some where we had a motion for temporary relief and we had a trial date and they were about 3 months apart. And the temporary relief got canceled based on a motion to continue. That was a totally legitimate motion by the other side.
Okay.
Okay. To the point where I didn't even object. Like, let's say the hurricane came and the court was closed. Like, it's just getting moved,
Sure. Right.
right? Then you go to the court docket and they go, yep, good news. We didn't think we had any time before the next 3 months of your trial, but we have a date available a week before trial. Well, now, do you take the date a week before trial?
Are you asking me? Because my
Yeah.
guess is it's going to be no.
And what's the reasoning for that?
Well, because it's going to cost you a lot of money when the ultimate decision may just be resolved a week later.
That's right. That's right. Very sound legal procedure theory. I'm with you.
Okay, except for this feels like I'm being set up.
Not being set up. What happens if the final hearing gets continued?
Then we will have
Now,
missed our opportunity for temporary relief.
that's right. And so then you go in there and the judge is looking at you like, really, Mr. Nelson, you're here on temporary relief and we got a week trial before trial. I'm like, yeah, judge, because I want to try this case a week from now. We are getting ready. And we just
Mhm.
gave you a little precursor, which, by the way, just tilted my hand on what we're going to argue in court a week from now because the other side
Yeah.
got to hear it.
Yeah, right.
But, Judge, I don't know what's going to happen in the next week. God forbid there could be a hurricane that floods everything and shuts us
Yeah.
down. So
Everything gets moved again. Do
I'm
you
here.
do you feel like that is like what you're describing, is that sort of part of your strategy? Do you feel like you're gonna take the temporary relief trial if it's important enough, you take it when you get it?
That's a client decision. And I'm
Okay.
going to have these conversations.
Okay.
That's a client
Interesting.
decision. So they sound good
Yeah.
and the concepts are great. Okay.
Mhm.
But it takes a while to get there. And, a lot of clients don't want to go to court. They're afraid of the unknown, and court is an unknown category.
Okay. Can I ask another question?
Hey, that's what we're here for, Pete.
I'm so relieved. I'm temporarily relieved. Uh, how are these things enforced? The judge says, you're now gonna have $7,000, and
A month
I
in temporary alimony.
yeah, in temporary alimony. What if Sam just says, "Screw you. You're not gonna have 7,000. I don't have 7,000 months to give. We're gonna leave court, and I'm just gonna say, "Oof, I'm washing my hands of it."
Okay. I'm going to turn the question back on you, Pete. You're a lawyer. You've done a great job. You got 7 grand a month for temporary alimony. You represent Alex, and Sam says, nope, I'm not paying. Okay.
Mhm.
What's the one thing you can do?
Do I file a motion that my opposing client is in contempt of the court's orders? Is contempt entering into it?
100%. I'll give you an A on that one. It's a motion for contempt
Okay.
and enforcement.
Do you know, in about 6 weeks, 6 episodes, I'd like you to just facilitate the bar exam for me. I'm just gonna take it. I think we're about there.
You're about there. You ready? Okay. I'll give you some doozies.
Yeah. Okay.
I still remember the premise of the bar exam question for criminal law. Like, I don't know all the specific facts of the question,
Yeah.
but I know enough of them that at the end of the show, I'll tell you.
We're
I
gonna
might
go
do it on
for
the
it.
air, but we'll see.
Okay. Member
Okay,
bonus.
but you're 100%. It is a
Okay.
motion for contempt and enforcement.
Okay.
Which now, what do you have to do with that? You file it with the clerk. What's your next step? Do you remember?
Well, don't you have to schedule a hearing?
Set it for hearing.
Yeah. And everybody knows you call the judge's clerk, and they love scheduling stuff
Yep, the
because they're
judge is
so good at
JA.
it.
You
They
got it.
JA. And then you'll get another hearing, and it'll probably be 4 to 6 months.
Well, it could be. It could be
Okay.
3 weeks if you get lucky. It could be
Yeah.
2 months. So yeah,
How often do you have judges who say, "I just heard this. Now he's in contempt. Let's get him back in here. Find a way."
rarely.
Okay.
Okay, they have 750 cases.
Okay.
You don't want to be your case that a lawyer ever remembers, or you especially don't want to be a case that a judge remembers.
Okay.
Because think of all the cases they have.
Yeah.
Only the bad ones stand out. Right?
Yeah.
That's not where you want to be. Okay. So we've covered what is it? Why is it important? Because it can even the playing field. Okay. What are the issues you deal with? Anything. They're all open.
Yeah.
Okay. Parenting plan, equitable distribution, alimony, child support, attorney's fees, cost. Okay. Pros. Get you in there, evens the playing field, like we keep saying. You get a little feeling about what the judge is going to doing. Cons. You might only get an hour or two to do temp relief. Okay. Ready? An hour or two. Let's be generous, Pete, and say we get 2 hours. We have 5 issues. The parenting plan, equitable distribution, alimony, child support, and attorney's fees and cost. Out of that 2 hours, you only get 1. Right?
Yeah, the opposing counsel
60
gets an hour.
minutes, 5 issues, just over 10 minutes per issue.
Yeah. I can see how sometimes how you feel like you might not, as a client, you feel like, how could you possibly make my case for temporary relief in that amount of time?
Parenting plan, 6113, subsection 3, A through T, 20 different factors that you need to go through in determining a parenting plan. You have just over 10 minutes, which means you got 20 factors and you put on your witness.
Yeah.
You've got to get through that very fast.
Yeah. 30 seconds per subsection.
Right.
Factor. Yeah.
Right.
That's okay. That's a disaster.
Right. And now we have to do financials. So hopefully you just say, Judge, here are the financial affidavits. They're totally different. Here's like 5 bank statements and some pay stubs. Like, I mean, it is so fast.
Yeah.
And then maybe it doesn't do what it's intended to do, which is to even the playing field.
Okay.
Right.
Last question for me. How often do you see motions for temporary relief throughout the case, the period of a long case, actually influence or impact a final judgment? Is that a consideration?
Yeah.
How so?
When someone's withholding the money and they think it's their money because there's a stay-at-home mom, let's say in this case, Sam's a stay-at-home mom. Alex has been working and Alex views every penny that they've earned during the marriage that he's earned through his employment as his money, not marital money.
Right.
It's all in his name. He goes, hires a lawyer in town because he's got a closely held business. He hired a forensic accountant. He's working through this case. He's talking to him. He's paying him a boatload of money. Sam doesn't have any access to cash. You go in there and you say, I need $75,000, and now he's got to write a check for 75 G's. That might wake him up because he views it as his money. And even though it says without prejudice, and we'll work it all out later, he now has to write a check to his wife's attorney for 75 grand. He now has to start paying his wife X number of dollars. He now gets what he wants, 50-50 timesharing. If you do, you better use it. Yeah. Sometimes I tell my clients, give them 50-50. they won't use it all. And then you go to court and say they don't use it.
And you get it back.
Right.
Okay.
So that's the issue. It can
Yeah.
influence, but you're not going to get a lot of time. And
Yeah.
I'm not blaming the judges.
No.
750 cases, totally packed docket. I mean, I went on temporary relief. It was a full day. And the judge is like, I gave you a lot of time. Right.
Yeah.
And that case was already set for temp relief. I got on it like the week before. And literally, I picked up the file and went for a full day hearing on temp relief.
Fascinating.
So you do what you got to do.
Temporary relief, you do what you got to do. Hopefully this discussion at least helps folks understand what temporary relief is, the tool that it is in service of your divorce case, and how thoughtfully you need to approach temporary relief when attempting to wield it. I have a listener question.
Nice. Let's do it.
So this question is special. It is anonymous because it was asked to be anonymous, but I know who it is, and I think you'll get why momentarily. Are you ready?
Is it Andy?
It's not.
Okay.
It is not. It is not Andy. The question is this. This question shouldn't be a surprise since I just had coffee with Pete about an hour ago, and I asked him this, and he punted it back to the show. What a guy. The question is this. Can a 19-year-old child sue his divorcing parents for a stake in marital settlement? Is there even a chance that this will be heard? Thank you, guys. New listener and already loving the show. Pete paid for coffee. #win.
Okay. Let's break this down a little bit. I want to start with you paid for coffee?
Yeah.
You've never bought me a cup of coffee?
You live in Florida. Come on out here. I'll buy you some Portland brew.
What? You're about to say we don't have coffee in Florida? Okay. So this is an adult child trying to sue his divorcing parents for a stake in the marital settlement.
Yes.
So
have you ever heard a question like this?
No, but it's like one of these like law school exam questions. So I think you planted a bar question on me here.
Excellent.
So the issue is any of what they're claiming to be marital assets actually the 19-year-old's money? So let's say there is an account, a bank account that is has the child's name on it that you started, and it has a parent's name on it. And you guys are saying, that was always our money. We just put it in. We were going to use it for their college education. And the 19-year-old's like, my name's on that account. That's mine. Okay. So, but if their name's not on any account and their parents are getting a divorce, the adult child would not have what we call in the legal world standing. Think of this. This child doesn't have the right to stand in court in front of the judge to have their issues heard because they're not part of this.
Yeah.
Right?
Okay.
If you are in a dispute with Andy, right?
Hard to believe.
I know it's hard to believe. But if you are, and it's about you contracted with Andy to do a different podcast that had nothing to do with me, and Andy totally screwed it up, and now you got to sue his ass. I don't get to go into court and say, I want a piece of that action. Yeah. Right? Because they have business together and they run True Story FM, which is amazing. And I have a podcast.
You have no standing.
I don't have standing. None of my business.
Okay.
Now, courts are open to the public. So this 19-year-old can go sit, not stand, sit in the back of the courtroom in the galley and watch the proceedings, but you don't get to talk. You're not in there. You're just a spectator.
Okay.
So this is a really good way, though, for a 19-year-old to get cut out of the wills.
There you go. I mean, it really seems like it's also a great way for a 19-year-old to try and get ahead of the wills. Like, I'll just take it now. Right?
That's true. That's a good point. I didn't think of it that way. Sue them. Sue your parents.
I actually think that's a fascinating question. Just sue the parents. What I mean, some insects eat their parents after they're born, I guess. That's
Right. Now, sometimes
gross.
your adult child might be in there if there was a trust
Yeah.
that was a revocable or non-revocable trust, depending on, well, it'd really be I guess, a non-revocable trust, which wouldn't be a marital asset, but maybe you're looking over that. And so the state and trust law comes in. There's a lot of what ifs, but it's basically, excuse me, does the 19-year-old have an asset
Mhm.
involved in this divorce?
You can't just say, "Hey, I'm 19 now. My parents are getting divorced. They're very wealthy, and I want to share because I
No,
was a part
that's
of the
out.
party."
But like by way of example, I have a rental property. It's where I used to live. I got married. I didn't sell it, living with my wife.
Okay.
So, my son has a very, very small stake now in that rental property. Okay.
Mhm.
So let's pretend I would die. I'd be in a body bag before this happens. But if I'm getting divorced from my current wife, okay,
Okay.
Kai would actually have a stake in this because if I'm putting marital money into this rental property and Kai has a piece of it, see, he has part of this asset.
Mhm.
And part of it's marital, part of it's non-marital because I had it before marriage, and part of it belongs to him.
Okay.
So
So
he
you
would
can
allowed
see
to come
why.
to court and make some arguments there, but that's very similar to being on a bank account, right? You're
Yeah.
just on an
Right.
asset.
Right. And you're only making the case about a specific asset.
That's right.
Okay.
Right.
That
You
makes
don't
sense.
get to
Well,
say, you know what? Grandpa gave dad a watch and now they're getting divorced. I want the watch. No, it's your
no.
dad's.
Got
No.
it. Well, I appreciate the question. I think it's fascinating, especially if it brings you back to law school just a little bit.
Yeah.
And thank you for sending it. If anybody else wants to send more questions, we just did an epic, I have to say, epic listener question episode that is, I think, just came out. And we're very excited about listener questions. But this was the first and only listener question since we recorded that episode just days ago. So we're ready.
Right.
We're ready
I
to
mean,
take
we
them
just
on.
did that show. So
I know. Yeah, days
yeah.
ago. So go ahead, send us some questions. Howtosplitatoaster.com. Type in your question right there where it says submit a question, and Seth will answer it just like he did this one today. It's fantastic. Thank you, everybody, for your curiosity and your engagement. We appreciate it. That's it. That's what we have for today. Thanks very much for listening. Thanks for your time and your attention. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we will see you next week right here on How to Split a Toaster, a divorce podcast about saving your relationships.